If you're listening today, chances are you're either dreaming about buying your first home, preparing to invest in property, or maybe you already own one and want to understand the legal side of things more clearly. Buying a home is one of the biggest milestones in life. For many, it represents stability, independence, and success. It's a place where memories will be made, families will grow, and futures will be built. But behind the dream of homeownership lies a world of rules, rights, and responsibilities that aren't always obvious. When people talk about buying a house, they often focus on the emotional side, the excitement of getting keys, the joy of decorating, the pride of calling a place your own. But few stop to ask, what does it actually mean legally to own a home? The truth is, homeownership is not just a personal milestone. It is also a legal contract with society. When you buy a home, you don't simply acquire four walls and a roof. You step into a web of legal relationships with the government, with lenders, with neighbors, and even with future buyers or sellers. And understanding those relationships can mean the difference between a smooth, rewarding ownership experience or years of headaches, disputes, and financial loss. When most people say, I own a house, they mean they live there, they pay the bills, and the property is theirs. But in the eyes of the law, ownership is much more precise. Let's break it down. 1. Titles and deeds. At the core of homeownership lies the title. Think of the title as the legal right of ownership. It's not a piece of paper you hold in your hand. Rather, it's the concept, the recognition that you are the rightful owner of a piece of property. The deed, on the other hand, is the document that proves that transfer of ownership. When you buy a home, the seller signs a deed, which is then recorded with the local government office, often called the Deeds Registry or Land Records Office. This recording is crucial. Why? Because it establishes publicly who owns the property. If a dispute arises years later, the record speaks louder than memory. Now, not all deeds are created equal. There are several types, and each carries a different level of legal protection. General warranty deed. This is the strongest form of deed. It guarantees that the seller has clear ownership, free of debts or claims, and has the right to sell. It also promises to defend you if someone later challenges your ownership. Special warranty deed offers a narrower guarantee. The seller only promises that during their ownership, the title was clear. If there were problems before they owned it, you might be on your own. Quitclaim deed, the weakest. The seller simply gives you whatever interest they might have, which could be full ownership or nothing at all. Quitclaim deeds are often used between family members or to clear up small title issues, not for major purchases. Imagine this scenario. Sarah buys her first house. She doesn't pay much attention to the type of deed. Years later, a man shows up claiming that part of her backyard actually belongs to him, based on an old family inheritance. If Sarah received a general warranty deed, the seller is legally obligated to defend her claim. But if she got a quitclaim deed, she may have no protection at all. This example shows how important it is to understand the paperwork at closing. Titles and deeds are not just formalities. They're your shield of ownership. 2. Encumbrances and liens. But wait, even if you own the title, it doesn't always mean you own the property free and clear. Properties can carry encumbrances, legal restrictions or claims attached to them. For example, a mortgage lien means the bank still has a legal claim until you finish paying your loan. Easements give someone else a right to use part of your property, like a utility company having the right to dig for electrical lines. These don't necessarily prevent you from owning the home, but they shape what your ownership looks like. That's why title searches are so important during the buying process. 3. Joint ownership. Now let's talk about who owns the home. Many people buy houses jointly, with a spouse, a partner, or a family member. But the law recognizes several different forms of joint ownership, each with its own consequences. Joint tenancy with right of survivorship. If one owner dies, the other automatically inherits their share. This avoids probate court. Tenancy in common. Each owner has a distinct share, which they can leave to heirs in a will. Community property, in some regions, property acquired during marriage is considered owned equally by both spouses, regardless of who paid for it. Here's a real-world example. John and his brother Alex buy a home together as an investment. They choose tenancy in common. Years later, John dies, and his share passes to his daughter, not to Alex. Suddenly, Alex finds himself in co-ownership with his niece. This outcome surprises many people who don't realize how ownership forms matter. Understanding your form of ownership is vital, not just for today, but for what happens in the future. Fourth, recording and public notice. Every deed must be recorded with the local government. Recording isn't just bureaucracy, it's protection. Suppose two people claim to buy the same house. The one who recorded their deed first generally has the stronger claim, even if the other person paid earlier. Recording provides public notice, a way of telling the world, this property now belongs to me. This is why real estate closings always end with the deed being sent to the recorder's office. Why understanding the legal foundation matters. So why spend so much time on this legal groundwork? Because without clarity on deeds, titles, liens, and ownership types, buyers can walk straight into problems. A buyer may think, I paid for the house, so it's mine. But if there's a tax lien, or if the seller didn't actually have the right to sell, that ownership could crumble in court. Knowing these fundamentals is like building your house on solid rock, not shifting sand. Take a moment to reflect. If you're considering buying a home, ask yourself, do I understand what kind of deed I'll receive? Have I considered how I'll hold ownership, alone, jointly, or in common? Am I aware of liens, easements, or restrictions that may come with the property? These questions may seem technical now, but they are the legal backbone of home ownership.